Defense Attorney Tadisha Rowe, bringing you another episode of Immigration Dream University, brought to you by American Legal Immigration Center in the DMV of the United States. I hope that you guys are doing well, whatever time of day or night or evening, afternoon, whatever it is, wherever you are. It is actually pretty late here in the DMV. It is 7:49 p.m. right now. We're just in the office cranking out some things. Sometimes, you have to do what you have to do. So sometimes we are here a little bit later, but fortunately this doesn't happen on a regular basis. But I wanted to get a video out to you guys quickly just to explain, and hopefully this information is going to be useful to someone, to explain about how we recently responded to a notice of intent to deny a special immigrant juvenile application for one of my clients, and what we did to overcome it. And hopefully, again, this information will be helpful to you. So I've done quite a few number of videos at this point on special immigrant juvenile visas, and they are for children who've been abused, abandoned, and or neglected by one or both parents. And they have to be unmarried, they have to meet the age qualifications of being under 21, but in order to get the predicate orders or the initial orders to even qualify for to submit your application to USCIS, you do have to meet your state's age qualifications. In some cases it's going to be 18. I've seen quite a few different ages, but it's typically 18 or 21. Fortunately, in the DMV area, Maryland specifically is 21, and in a few of these surrounding states it's also 21, so we are very fortunate here. So recently I got a notice of intent to deny from USCIS, and there wasn't actually much time given to even respond to the notice. A notice of intent to deny, it's different from a request for evidence. A request for evidence is saying they haven't made a decision either way or the other, but this information is missing in order to help them along with that decision. Notice of intent to deny means that they've basically reviewed everything. They feel as though they have everything that they need to make a decision, and right now they are leaning towards denying that application unless you can address whatever it is they mentioned in that notice as to whatever it is that they're looking for. So in my client's case, he came to the United States as a child, and he was seeking two forms of relief. One was for asylum because he was actually in immigration removal proceedings. He came fleeing harm from his country. He was also abandoned by one of his parents when he was a child, and for the majority of his life he briefly reunited with that parent here in the United States. However, that parent was not consistently a part of his life. And so, the information that he gave from somebody who was looking at it for the first time and maybe didn't have the full picture of what was going on would think that, oh, this child is making this story up because here it is, they said that their parent has abandoned them, but it looks like the parent provided money for them when they were living in a different country. It also looks as though they lived with this parent for some time or quite a period of time while they were here in the United States. So it appears that they're just filing this application for immigration benefits only, and we know that that is always going to lead to a denial if you're only doing something or making something up for immigration purposes. I felt very confident in my client, even with taking on the case, because I usually get a good feel for my clients now, know where they're coming from, and I understand their stories and whether or not somebody's making something up or if they're bringing a truthful story and they're saying, hey, this is what's going on, how can you help me? So in this case, it turns out that the parents, they were still kind of sort of together, but not willfully. And as many of you know, a lot of abuse goes on, especially in many countries. There's still a lack of protection for particularly women in abusive relationships. And so the mother in this case was in a very difficult relationship with the father and just didn't understand the rights that she had. And so there was a large portion of time where the father would be absent from the home, and even if he was there, he was abusive to the child or neglectful to the child. He refused to provide for him. So many different factors that qualified this child for abuse, abandonment, and or neglect or a similar basis, so that he could qualify for the special juvenile visa. So during the course of our attorney-client relationship, I was actually able to advise her about her different rights, learning, you know, once I learned what it was that she was going through. And so she did eventually get a divorce and from her husband, and she was able to start building a more safe environment for herself and her children. But of course, her husband, well, I shouldn't say of course, but in this instance, he continued to try to come back and to do different things. It just so happened that around the time that this notice of intent to deny was issued, she actually had to call the police on him to have him removed from the home because he refused to leave. And so that was part of the evidence that was included in answering this notice of intent to deny this child's very deserving qualification for special immigrant juvenile. And you know, we were able to send everything in, although like I said, we didn't have much time to address the notice of intent to deny. They gave us just about 30 days, which in the legal world is practically nothing. And so we really had to scramble and get everything together and make sure that we got it there on time to make the deadline, and we certainly did. We got the decision at the end of last week, and I want to say we submitted it it reached them on a Monday, and by Wednesday they had reviewed it and issued their approval for this child. This, again, like I said, very well-deserving child to get their special immigrant juvenile status. So the wonderful thing is that in the meantime, they had also advanced his hearing date for immigration court. When they advance a date, that just means it's going to happen sooner than you believe. So before we thought we had until 2024, suddenly his hearing date was going to be the next month. So about 4 weeks after that response was due, not even 4 weeks actually, about 3 weeks after that response was due, he was scheduled to go to trial for his asylum application. So you can just imagine the amount of pressure that we were under. But again, you know, that's what we're made of. We don't back down. We work very hard for our clients. We are a very strong and solidified team here. It's not just myself. I have a wonderful, wonderful team, as I say. And I think, you know, as time goes on, you'll get to meet the people who are behind the cameras and just kind of running the show here along with me. So it's we have a very solid unit here. And when there's a crisis in the office, all hands are on deck to alleviate that crisis. So this was a wonderful story, wonderful ending for my client, and you know, hopefully this will help someone else who may be faced with something similar. If you do happen to get a notice of intent to deny, don't fret. Just make sure that you take very quick steps and very strategic steps to answer, and just put yourself in the shoes of the government or a third party who's looking at your case for the first time with objective eyes and may not know exactly what's going on, and then try to bring the story to life for them through your paper, whatever you respond back on paper to them, and then also documentation that you submit to them. All right, guys, so as usual, good morning, good afternoon, good evening, good night, whatever it is.